Yo, what up, guys? It's Derp here with another video about the IronMace vs. Nexon court case. The purpose of today's video is to cover a few minor events that may or may not have a lasting impact on the court case as it moves forward. So what I'm going to cover is the death of Nexons CEO that happened last year, and how the sale of shares by Nexon's parent company might impact the court case. Nexons Surreply, what it is and what we can expect, what happened in Korea on the 19th, so today, and what happens after that. And then I'm going to give a quick TLDR at the end of the video, as well as like a quick timeline update, which is something that I've been adding to the most recent videos just to kind of keep it rolling along. So there haven't been many huge documents since the last video, but I do want to address some things that might have a lasting impact on the case that seem minor right now, but they might impact the case greatly. Especially the possible sale of almost 30% of NXC shares, and that's the company that owns Nexon. Unfortunately, the owner of NXC and therefore Nexon and all of Nexon's subsidiaries passed away last year, and they're having to sell shares to cover some inheritance tax, but I'll go over that later. As always, huge thank you to everybody who's been watching, subscribing, leaving comments, and joining the guild. I want to thank the Andrews personally. You guys know who you are. The Battle of the Andrews was pretty epic on stream the other day, and because of you, I have this new light, this new mic, the mic stand. I upgraded the program I was using for my camera, which is my phone, but I got a new program for it, and I got a new camera stand. I also went and got a P.O. box, so now people have been asking if they can send me some stuff, and now I have a P.O. box so that people can send me some stuff. But yeah, thank you guys so much. I can't do this without you. You guys have helped me justify all these recent upgrades to my streaming setup. You know, I freaking love you guys. You guys are legend. Huge thank you to everybody shown here in the scroll for the supers, the memberships, and all the love and support you guys are showing me. You guys are amazing. But yeah, let's get right into it. So what's up with Nexon's parent company? Why are they selling shares? What happened? So according to Pulse News in Korea, in March of 2021 or 2022, I can't remember, the founder of Nexon passed away. I think it was 2022. I don't really want to get into how he died or anything related to his death. You know, it's a tragedy. Anybody dying is usually bad news, right? So we should be respectful and let their family go through their process. You know, it happened a year ago now, but they're still dealing with a lot of fallout. But what we need to know about this is that he passed away, and it is going to probably have a pretty big impact on Dark and Darker and the case with IronMace, because it's causing a major issue with Nexon's parent company, NXC. So NXC has officially been forced to give up 29.3% of its shares to the South Korean government due to some inheritance tax issues, after which the South Korean government will then sell off these shares to recoup the tax debt owed by the family of the founders of the company. So who they are going to sell it to, we don't really know yet. But there are some kind of crazy names being thrown around by the Korean media. One article is stating that one of the most likely buyers is the Crown Prince of Saudi Arabia. His name is Mohammed bin Salman Al Saud. Sorry for mispronouncing that. I butchered it. I'm sorry. I apologize. But he has been heavily invested in Korean and Japanese media companies, especially lately, and specifically for PC and mobile gaming industries. You know, and now apparently his eyes are set on Nexon specifically. So he wants to build out his portfolio within the gaming industries. And Nexon is a huge player in Southeast Asia, so he wants to, if he can get his hands on 30% of Nexon, he will. He's one of the richest people in the world, so he kind of gets whatever he wants. Another huge possible suitor is Tencent. They tried to purchase sales of NXC while the founder was still alive. However, that sale stalled and was ultimately shut down for pretty much unknown reasons. Currently, they are the sole distributor and publishers of Nexon games in China. Because of this, Tencent has a direct impact on a large portion of Nexon's overall finances, if not direct control over their most profitable market. So it would be pretty easy to see how they might want an even larger piece of that pie via a 30% stake in Nexon's parent company, right? So those are the two major players. How that's going to impact the court is really unknown. It remains to be seen. However, it might pull a lot of resources away from relatively minor legal issues such as the IronMace lawsuit. It might stall some acquisitions. It might just kind of upset the general flow of business because things are shifting around so much, which could be good or bad for the IronMace case. We don't really know yet. That's kind of unseen. So yeah, the resources might be pulled away to go towards the finalization of shares and integrating all of these new shareholders, if any. I mean, there is going to be some, but at least one, right? So one thing we do know is that whoever does end up purchasing these shares will not really have a majority or a managing stake in NXC or Nexon directly, as these shares are not what are called managing shares. So we shouldn't really worry about who ends up buying it and focus more on whether or not Nexon starts shifting focus away from, the smaller things like this court case in Nexon's eyes is actually relatively minor, right? They're a multi-billion-dollar company worth upwards of like $10 billion. So, like, to be perfectly honest, even like $10 million is a drop in the bucket. So they don't really care too much about the money aspect. Like, they don't really. This lawsuit is pretty much nothing to them. So let's move on to Nexons Surreply in the United States. What is it? What can we expect? This is kind of the meat and potatoes of this video. First, we need to know what a surreply is. According to uslegal.com, a surreply is an additional reply to a motion filed after the motion has already been fully briefed. For example, a legal document such as a motion filed by one party, the filing party, requested the court to enter an order. The other party, responding party, responds to the motion. The filing party then replies to the responding party's response. Some courts then allow responding parties to file a surreply to the filing party's reply to the responding party's response. I know that sounds confusing, but essentially a surreply is an argument made after the final scheduled argument in a motion. So all of the arguments are done, everybody's had a chance to reply and respond, and one party feels like they want to get another word in or another response. Oftentimes, this is used to file things like request to strike evidence or whatever, or propose that some part of the other party's argument is invalid, and that's kind of what is going on here. So there's some rules that go with surreplies, and I'm pulling these directly from Cornell Law and uslegal.com and places like Duke and stuff like that. But according to Cornell, oppositions, replies, and surreplies must comply with the content requirements for motions, and if the paper to which the opposition reply or surreply is responding contains a statement of material fact, must include a listing of facts that are admitted, denied, and cannot be admitted or denied. Any material fact not specifically denied may be considered or admitted. That last sentence is pretty important. And then part B of this rule is all arguments for the relief requested in a motion must be made within the motion. A reply may only respond to arguments raised in the corresponding opposition, patent owner preliminary response, or patent owner response or decision on institution. So the decision on institution would be decision on the court. So a surreply may only respond to arguments raised in the corresponding reply and may not be accompanied by new evidence other than deposition, transcripts, or cross-examination of any reply or witness. So that is also super important. So these rules mean that all surreplies have to follow the rules of the motion they are filed under, and all arguments made in the surreply cannot add any new information or witnesses, which is usually the case for most arguments in a motion to begin with, except for when they're accepted and permitted by a court, or when a party gives prior notice and gets prior approval for the court to add in this information. So this is kind of where things get tricky. Both IronMace and Nexon may have introduced new information and witnesses in the responses to the dismissal request. Nexon is most likely going to claim that evidence filed by IronMace stating that Nexon has never asked for source code is not allowed somehow, as stated in the request for a surreply. They will probably also ask for that evidence and that witness testimony in those declarations to be stricken. However, that information was given as a direct response to the new information that Nexon responded with to begin with, right? So the information that IronMace gave in their response was a direct reply to information that Nexon gave when they stated that they have been unable to receive source code in the discovery process in the Korean case, which they are trying to use as a reason for the Korean court being an invalid venue for all of their case. So essentially, both parties added information above and beyond the scope of the dismissal request and will probably argue to have each other's information stricken from the record. But this could actually lead down kind of a slippery slope and cause some issues later on. Essentially, both parties, added that extra information, and these issues later on are something called abusive briefing. I linked an article by the American Bar Association that states that repeated surreplies can be used as a way to stall courts into indecision and wasting one party's resources over another's. This is something that courts do not take very lightly, especially when one party is at a significant financial advantage over another. So, like in this case, Nexon already has a significant financial advantage over IronMace, which is pretty easily provable. So, stalling the case through surreplies is not something that the courts are going to be pleased with. It's like one surreply is chill. Multiple surreplies is not chill. So if this goes down that slope, it can have a lasting impact negatively for Nexon if they keep filing surreplies, and then if IronMace starts drawing it out, the judge will start getting mad too. So either party drawing this out through surreplies will be frowned upon by the court, because they don't want to waste the court's time, they don't want to waste the court's money, they don't want to waste Nexon's time or Nexon's money, or IronMace's time, anybody's money or time basically. Because of this, a lot of courts are hesitant to allow repeated surreplies and even more hesitant to strike arguments or disclosures without significant cause. So I've linked that article here, and I'll have it linked in the description below. And that's straight from the American Bar Association. In my opinion, Nexon surreply will probably be granted, and we will most likely hear the response by the end of the 19th. So as of today, by the end of today, as of recording this video. However, should they ask for more information to be stricken from the record, I don't think it will be granted unless they can provide an extremely convincing argument as to how IronMace is misleading the court or giving false information. But for now, we just kind of have to wait until they file their surreply, which should happen in essentially a few hours from recording this video. For now, I think the most important thing is to kind of focus on what happened earlier today in Korea, the finalization of the investigation into Nexon and IronMace's game code and their game comparison. So what exactly happened in Korea on the 19th and what's next? So today, July 19th, was an extremely important day for the Korean court case. It was the last day to file information and finalize investigation into P3 versus Dark and Darker. So time's up. Nexon can't request the source code or submit new evidence, neither can IronMace. Should either party have actually wanted this information, then the time to ask for it has already passed. This case is going to be moving forward pretty rapidly now. It will take a special motion to submit any new evidence from this point on, as to the best of my knowledge. That's kind of how it works in the United States and in Korea. Once you have like discovery and investigative periods, once those deadlines are up, they're up. The only way to get more information is to request it through the court. Hey, bird. Hey, cutie. Watch out, you're right in front of my camera. Yeah, come on. As for next steps, the investigative report should be available to the judge or a panel of judges by the end of July 21st. So 2 days as of 2 days from recording this video. After that, the court should have roughly 30 days to make a decision. I'm not entirely sure how that works in Korea, but from what I've heard, it's 30 days after the end of the investigation, not from the date of the reply. But either way, it should be the 21st of August, because the 19th of August falls on a Saturday. So it should be the 21st. That means that we should have an idea of how the Korean injunction case plays out within the next month or so, most likely on or before August 21st. First. Excuse me. So what's the TLDR? Quick timeline update. So the TLDR is fairly simple. Nexon was forced to give nearly 30% of its parent company's shares to the Korean government as an inheritance tax. So the Korean government is going to sell those shares most likely to the Saudi Crown Prince or Tencent. There's some other parties involved, but it doesn't seem like they are really in the running. There's two big players, and that's the Saudi Crown Prince and Tencent. So we don't know how it will impact this case, but it might pull resources away from, the relatively minor court case with IronMace. A few days ago, Nexon asked to file another argument and possibly strike a portion of IronMace's last reply on July 19th. Because this can lead to issues with delays and wasted funds, the court will probably allow the reply but refuse any motion to strike. We should know exactly what happens by the end of today. To add to this, Korean investigations into the differences and similarities of P3 versus Dark and Darker came to an end today. The results should be known by the court by July 21st and decided upon sometime by on or before August 31st. So while the 19th was the absolute first day the Korean courts could have decided on an injunction, it was never really a possibility. As I've kind of stated in other videos and in live streams, the investigation would have had to have been so conclusive that IronMace was either found 100% guilty or 100% innocent based on the evidence of the investigation alone. This is never really the case in any court, any reputable court system. We should expect to wait at least anywhere from another week to a month for the resolution of the preliminary injunction. And then after that, there's appeals processes and other stuff. And then they have to go to trial if it makes it that far, right? So at the earliest, we should probably hear something back about the Korean injunction and possibly early access within the next few weeks to a month in Korea. So yeah, in my opinion, we just need to wait and see how it plays out. I'm excited for this week. It should have a ton of information all within the next 7 days. The 26th is the deadline for early case conference. But yeah, here's some related dates. Here's kind of the breakdown for what's happening in the United States. The end of today, July 19th, is the Surreply deadline. The end of July, by the end of July 21st is the deadline for the motion to stay discovery until the dismissal is figured out. And then by the end of July 26th is the end of the early case conference, and it's the deadline for all the pretrial hearings. From there, it goes into discovery. So, and discovery is where most settlements happen. Something like 80 or 90% of all settlements happen in discovery period. And that's according to Duke and Cornell. So there's also related dates in Korea. July 19th was the end of the investigation into P3 and Dark and Darker. The 21st is when their report will be given over to the court. And then August 21st is around when we should have a preliminary injunction hearing. So that's pretty much it. Thanks for watching, you guys. As always, you're all champions. I love you guys. I want to thank you all for your support. I'm sorry if my last few videos were a little clickbaity or unbiased. I love IronMace. I want the game to come out. Sometimes that bleeds into my work with this channel. But I promise to do better in the future. I just want to have fun here, and I want to give the community information that they love. And that they could trust and rely upon. So, yeah, thank you guys. Thank you guys for your support. Thanks for sticking with me. I've been, massively fortunate to explode to over 1,000 viewers. I'm almost at 1,200 already by the end of the month. By the middle of the month, I might reach 1,500 by the end of this month, which would be insane. My goal was 1,000 by the end of this month. So, yeah, don't forget to like, subscribe, hit that bell icon if you want more content faster. Be sure to join the guild by either following the YouTube membership or Patreon link below. Join the Discord. You'll get your name into the scroll if you join up on Patreon or the YouTube membership, just so everybody knows how awesome you are. Love you guys. Peace. You guys have an amazing rest of your day. Hold the line. Later.